Hello, I'm Anoushka, and it gives me great honor to welcome you to this webinar. This webinar is a part of the Legal Awareness Initiative taken by the Law Gurukul. Today's webinar is a rather sensitive one, as we are going to talk about the Prevention of Sexual Harassment Act, commonly known as the POSH Act. Our presenters, Ms. Samatha, Ms. Sudeepthi, Ms. Shabnam, and Ms. Mansi have worked to the best of their ability to simplify what amounts to sexual harassment and the redressals available in case you suffer from such sort of harassment. I hope this webinar will prove to be an enlightening one for you. I'd now like to hand over the stage to Ms. Samatha, who will define what amounts to sexual harassment. Over to you, Samatha.
Thank you, Anoushka. Hello, everyone. I am Samatha Behara. Now, I am going to speak about the legal definition of sexual harassment. Sexual harassment is an unwelcome sexual advance, unwelcome request for sexual favors, or a other unwelcome conduct of a sexual nature which makes a person feel offended, humiliated, where a reasonable person would anticipate the reaction in the circumstances. The Sex Discrimination Act 1984 defines the nature and circumstances in the sexual harassment is unlawful. It is also unlawful for a person to be victimized for making or proposing to make a complaint of sexual harassment to the Human Rights of Equal Opportunity Commission. Examples of sexually harassing behavior include unwelcome touching, staring or leering, suggestive comments or jokes, sexually explicit pictures or posters, unwanted invitations to go out on dates, requests for sex, intrusive questions about the person's private life or a body, unnecessary familiarity such as deliberately brushing upon against a person, insults or taunts based on sex. A working environment or a workplace culture that is sexually hostile will also amount to unlawful sexual harassment. Some of the factors emerging for the case laws which may indicate a potentially hostile environment include the display of obscene or pornographic materials. The Sex Discrimination Act makes sexual harassment unlawful in many areas of a public life, including in employment situations, educational institutions, the provisions of goods, services, and accommodation, and the administration of Commonwealth law or programs. Under this Act, workplace includes any government office, companies, organizations, private sector organizations, NGOs, societies, trusts, hospitals, homes, schools, sports institutes, places visited by the employee during the course of work. Next slide. Coming to POSH, the Sexual Harassment of Women at Workplace Prevention, Prohibition, Redressal Act 2013 POSH Act defines the workplace as any place visited by the employee arising out of or during the course of employment, including transportation provided by the employer for the purpose of commuting to the and from the place of employment. It is a legislative act in India that seeks to protect women from sexual harassment at their place of work. The Ministry of Law and Justice has passed the act on April 2013 and rules were passed on December 9, 2013. The POSH Act was enacted to ensure safe working spaces for women and to build enabling work environments that respect women's right to equality of status and opportunity. Coming to the objectives of the POSH Act, protecting against sexual harassment of women at workplace, prevention by bringing awareness on POSH Act, redressal of complaint of sexual harassment. Now, Sudeepthi Veeravilli will be explaining the history of POSH Act. Over to you, Sudeepthi.
Thank you, Samatha. Hello, my name is Sudeepthi, and today I will be discussing about the history behind POSH Act. We all know the fact that since ancient times, women have been subjected to harassments in the every working place. So this menace has started before we actually don't know the word what is sexual harassment and its bad intentions. Since the beginning of industrialization, the large number of women had started to work in factories. and they are among sexually harassed cruelly by their bosses at workplaces. According to the Indian Constitution, these situations led to the violation of fundamental rights of Article 14, 15, and 21 of women. And in recent years, the Me Too movement erupted all around the world. In inspiration of these, millions of sexual harassment victims have dragged their complaints to the public notice, and due to this, many high profile persons were accused in the scandal. So, to protect these women and to punish the accused, we need a strong legislation which should specially focus on all the guidelines in the favor of sexually harassed women. So, in 1997, Supreme Court laid a special guidelines in the case of Visakha versus State of Rajasthan. So, these guidelines are later emerged as POSH Act. So can we have next slide, please? So before the introduction of POSH Act, there was no statutory remedy that directly addressed workplace sexual harassment except the IPC provisions. So the only sections under the IPC that could be used for sexual harassment. So these sections are Section 354. It explains the outraging the modesty of a woman. And another one, Section 509. It tells about the insulting the modesty of a woman. So the application of these sections of IPC can seen in the case of Rupan Diol Bajaj versus KPS Gill. In 1995, where a senior IAS officer was sexually harassed by a superior officer, and this limited provision of the IPC under section 354 and 509 as discussed above was not found sufficient by the High Court. And adding to this, the unfortunate circumstances in the Vishaka case finally addressed the definition of sexual harassment in workplace as explained by Samatha, and its prevention and readdressal mechanisms that I will be discussing in further slides. The next slide. So in landmark judgment of Vishaka versus State of Rajasthan, in the year 1997, Rajasthan state government employee Banwari Devi tried to prevent a child marriage. So Banwari Devi is the worker of Women Development Program. So she was raped by the landlords. Then the trial court had acquitted the offenders due to lack of certain provisions. This enraged several women's group, and they filed a writ petition in Supreme Court of India. Then the Supreme Court stated that every instance of sexual harassment is a violation of fundamental rights which are guaranteed under Article 14, 15 and 21 of the Constitution of India. And it also amounts to violation of the right to freedom under Article 19. From this case, the Supreme Court also noted that the present civil and penal laws in India do not provide adequate protection for women from sexual harassment in workplaces. So in this landmark judgment, the Supreme Court of India created legally binding guidelines based on the right to equality and dignity according to the Indian Constitution, and as well as by the UN Convention on the Elimination of All Forms of Discrimination Against Women, which is also called as CEDA. So India is one of the party of CEDA Convention. Then India borrowed the aspects of equality of women in the workplace, gender-specific violence, and unwelcome sexually determined behavior into the POSH Act. The next slide. So the Vishaka guidelines. The Vishaka guidelines were instituted by the Supreme Court of India to ensure the safety of women at workplaces. It laid down the guidelines for dealing with the cases which are related to sexual harassment at the workplace. The first one, Vishaka guidelines, the first one. Yes, a definition of sexual harassment. This definition was covered the situations where a woman could be feel uncomfortable in her workplace that negatively affect her working life. And the second one, shifting accountability from individuals to institutions. So the guidelines had placed the responsibility on employers and it prohibited victimization with an inquiry, including the affected complainant as well as witnesses. And the next one, prioritizing prevention. All employers or persons in charge of workplace, whether it is public or private, should take appropriate steps to prevent sexual harassment. And the next, provision of an innovative redress mechanism. So the complaints committee were mandated to be headed by a woman employee, and whether the complaint provided for the involvement of a third party person or NGO expert, whether any undue circumstances arises on the issue. And the last one, duty of government to widen the scope of these guidelines. So these guidelines urges the center and the state government to pass the necessary legislation so as to ensure that the private sector is also bounded by these guidelines. So these Visakha guidelines were later replaced by the Sexual Harassment of Women at the Workplace Act 2013. It is also known as POSH Act, which we call as Prevention, Prohibition and Readdressal. So this new act passed in 2013. It broadens the definition of aggrieved women of all ages, which suits the modern day conditions. So now my friend Shabnam will be discussing the key provisions of POSH Act. Shabnam, over to you.
All right, am I audible? Am I audible? Somebody please respond. I was sharing this. Okay, all right.
Much more audible.
Yes. Sure. All right. So good evening to all. I had a bit of technical issues, but now everything is fixed. And we have known the history of POSH Act and specification in terms of what sexual harassment actually is and what is defined as a workplace. Now we'll divulge into the actual provisions of the POSH Act. And according to Section 1 of the Act, of course, the full form of it is Sexual Harassment of Women at Workplace, Prevention, Prohibition and Redressal Act of 2013. Now, who are the beneficiaries? Basically, all employed women, including those from the unorganized, organized sectors who are daily waged or receive full salaries or are just employed for even temporary work. It also includes domestic workers who work at different houses and so on. So basically, it's a woman-centric law that covers all employed women. Now, moving on to the actual act, the first three chapters are regarding their basic structures. Now, I won't go into much details of chapter 1 because Samatha has almost already covered all the important aspects of it. So now we'll start with chapter 2, which is regarding constitution of internal complaint committees. Now, according to section 4.1 of the Act, every administrative unit or office under an employer should have an internal complaints committee. But there is a rather jurisdiction to it. There need not be such an internal complaints committee in offices with less than 10 employees and so on. Moreover, these committees, according to section 4.2, should be headed by a presiding officer who should be a senior woman from the office. If such a position is not handled by a woman, it could be also a senior woman from other offices or other departments under the employer. It's also to be noted that at least 2 of the members should be a social worker or somebody with legal knowledge, and there should be at least 1 person from the committee who is part of an NGO. It is also to be maintained that half of the committee should be all women. Now, this isn't a permanent committee. Of course, according to section 4.3 of the Act, it is prescribed that this nomination process should occur at least every 3 years. And in case the presiding officer fails to execute his or her duties, then, not his or her duties, then according to section 4.5, that person is to be removed. Now, moving on to chapter 3. Constitution of a local complaints committee. Now, what is a local complaints committee? According to Section 5 of the Act, the government may notify a district magistrate, additional district magistrate, collector, or the deputy collector of a district as the district officer for them. And this district officer under Section 6(1) shall constitute a local complaints committee. Now, who are this LCC going to redress? This basically for aggrieved women who don't have a ICC in their company or under the employer, because the number of employees must be less, and for other employed women like domestic workers, they also aren't covered by any ICC, so they can directly take their complaint to their district's LCC. Now, moving on, the complaint system and the inquiry system that is prescribed by the POSH Act is covered under Chapter 4 and Chapter 5. Now, let's look into that. According to Section 9(1) under Chapter 4, the complaint should be in written form and must be submitted within 3 months of the incident. If it was a series of incidents, then the complaint should be given within 3 months of the last incident. And if the person has any difficulty in writing a written complaint, then of course the ICC and LCC should give the aggrieved woman aid in writing such a complaint. Moreover, according to Section 9(2), if the aggrieved woman isn't of physical or mental capacity to do so, or has passed away in subsequently to the harassment or any other issue, then the legal heir can also file a written complaint on behalf of the aggrieved woman. There's one other interesting section in this, Section 10(1), which provides a scope for conciliation between the respondent and the aggrieved woman. And if such an inside settlement is reached by both of them, then according to Section 2, the ICC or LCC is responsible to inform about this settlement to the district office of the district or the employer to make sure that this settlement is executed. Also, after the complaint is filed, according to Section 11 of ICC, an inquiry should be begun. If it's by ICC, it could be in terms of their provisions, or if it's from behalf of the LCC, for example, in the case of a domestic worker, then this inquiry process should be, handled by the police within 7 days. And since we are moving on to the police, usually the inquiry is based on a violation of Section 509, which our friend Sudeepthi had already explained, is regarding insult to modesty of a woman. So moving on to inquiry into complaint. Basically, during this inquiry period, according to Section 12(1), the woman can either request for her own transfer or the transfer of the respondent, or she can take leave for the period, or some other form of relief can be given to her. Now, the important nature of it is this shouldn't be eating up on the existing privileges given to her. In the sense, if there is a specific set of paid leaves, this should be in addition to that. Then, according to Section 13(1), it is mandatory that the findings of the inquiry is to be submitted to the employer. Also, in terms of paying this, according to Section 13(3), the compensation to be paid can be taken either from the respondent's salary, and if he is not in a position to pay from the salary, he would have to himself facilitate the payment. Now, when we're talking about compensation, we might be wondering what all factors have been considered for this. This is described in Section 15 of the Act, in which the following factors are considered. First one, the mental trauma, pain, suffering, emotional distress, and other physical distress caused to the aggrieved woman. Secondly, the loss in the career opportunity because of this. Thirdly, the loss in the Thirdly, the feasibility of such a payment in lump sum or in installments. Fourthly, the medical expenses incurred by the victim. And last, the income and financial status of the respondent. All these are to be considered. It is also interesting that according to section 16 and 17, the privacy of the aggrieved woman is also to be protected, and any information that is outside the scope of Right to Information Act of 2005 is not to be published to the press. Now we'll talk about the duties as a district administration or our employers have towards their employees. The chapter 6, 7, and 8 covers it. 7 and 8 are not very relevant to the layman, so I will only be explaining 6 to all. Basically, these are the simplified duties. 1, to provide a safe working environment for the employees. 2, display the penal consequences of workplace sexual harassment. 3, employees should undergo POSH training at least once a year. And 4, conduct orientation programs for the ICC. 5, assist in any manner required to enable the aggrieved woman to receive justice according to law. And 6, at least one half of the ICC should always be all women. With this, we've covered almost all the important provisions of the POSH Act. Now, Mansi Jain will be explaining to you the redressal systems that exist within the scope.
Thank you, Shabnam. Good morning, everyone. I am Mansi Jain. Will now discuss the remedies that are available to the victim who face sexual harassment at workplace under the POSH Act. So, to begin with, the first remedy is forming an internal complaint committee under Section 4 of the POSH Act, which says that any company with 10 or more employees is required to form an internal committee to handle sexual harassment allegations. The internal committee also has the authority to suggest a number of remedies, including warnings, counseling, community service, suspension, denial of advancement, or even termination of the employee. Now, the second remedy is that before the commencement of the POSH Act, the women were left to file a criminal case under Section 354 of the IPC and also Section 509 of the IPC. But after the commencement of the POSH Act, under Section 9, the woman who is a victim of sexual harassment can file a complaint directly to the internal committee against the respondent in writing within 3 months of the incident or the last incident. However, if the complainant made a false complaint, then the internal committee can take action against the complainant as well. Now, the third remedy is that the victim of sexual harassment can seek the transfer of the accused or her own for 3 months during the investigation period under Section 12 of the POSH Act. Now, moving on to the fourth remedy, it is that the victim of sexual harassment has the right to file a civil as well as a criminal case against the accused. Under a civil remedy, the victim can claim compensation under Section 15 of the POSH Act, which says that if the respondent fails to pay the compensation, internal committee may forward the order for recovery of the sum to the concerned district officer. And under criminal remedy, she can file a complaint under Section 354 of the IPC and under Section 509 of the IPC, in which accused, if found guilty, can be punished for a term which may extend to 3 years and fine. Now, the fifth remedy is that the victim can seek interim relief during the course of the investigation. That is, the victim can seek restraint order against the respondent from reporting on the work or writing confidential report to the victim, and she can also seek restraint order against the respondent from supervising academic activities to the victim. The last but not the least remedy is that if the victim of sexual harassment is dismissed from the job, then in that case, she has the right to complain directly to the boards of directors of the company that her removal is arbitrary in nature and she has the right to continue her job. Now, if we will go on to the next slide, as the world is struggling with its most serious pandemic, that is COVID-19, remote work has become the new normal. For business meetings, platforms like Zoom, Skype, and Meet have become the go-to option. But do you all know that many women have filed complaint of online sexual harassment during the nationwide lockdown, such as receiving unwanted video calls at odd hours, receiving unnecessary messages, and so on. Every day since the lockdown was imposed, there have been 4 to 5 such complaints, and many women are afraid of losing their jobs and are unaware whether they will be fired or not because of it. Women are constantly second guessing whether it was harassment, where to draw the line, and how to define offensive or indecent body language because they have never experienced absolute work from home before. And you must have heard about the recent incident in which many female law students came forward on LinkedIn to share their internship experience and harassment they faced while interning online. So, in this all cases, what practical steps that can be taken by the company to prevent the online sexual harassment at workplace, which is increasing day by day? The first step is that the council should meet with the individual in question and address the issue promptly in order to prevent it from happening again. That every company has anti-harassment measures in place. All of these concerns are addressed by a proper council. Women should be allowed to express their concerns anonymously and share the complete story. That the organizations or companies must ensure that the existing POSH policies are evaluated and updated to reflect changes in working arrangements, such as the increase in remote work and the use of digital technologies. The employee should be given clear instructions on how to report any instances of sexual harassment, that a POSH policy should be available on the company's website or another remotely accessible source, and it should be convenient to use, that if an employee makes a sexual harassment complaint, it should be addressed with sensitivity, accuracy, and speed. The effective execution of the POSH Act is not only required for creation of an atmosphere in which women may speak about their problems without fear of repercussions and receive justice, but also for the education of males towards the treatment of women at work. Thank you, everyone. Now, Anoushka will further conclude our webinar. Over to you, Anoushka.
Thank you, Mansi. The following details of the various NGOs that you can see displayed on your screen will help you in case you suffer with any sort of sexual harassment. You are more than welcome to note down the numbers or the email IDs to get in touch with everyone. Now that we've come to an end of this webinar, I would like to thank my presenters for such an insightful presentation. I'd also like to take this opportunity to apologize for all the technical difficulties we faced during the webinar. Last but not the least, thank you all for joining us, and we hope this webinar was helpful in understanding the history and provisions of the POSH Act, as well as help you understand the remedies that are available. I am Anoushka Coutto, signing off until next time.